You're 11 days from closing. The title company calls. And they say the 6 words that kill more Florida home sales than any inspection ever has. There's a problem with the title, and nobody ever explains what that actually means. So today I'm handing you the five title problems that stop Florida sales, what each one really is, what the fix costs, and how long the fix takes. All 5 have a fix. Not one of them means you can't sell. I'm Anthony Astolfi, the owner of Home Rescue Team and a licensed Florida real estate agent. I sit with families across Broward and Miami-Dade who just got that phone call. This is education, not legal advice. For your specific chain, you want a Florida real estate attorney or your title company. So first, understand what they're even looking at. Title is not a document. Title is a chain. Every single time your property changed hands or got borrowed against or had a lien recorded against it, going back decades, somebody filed a piece of paper at the county. A title search reads that chain forward, link by link, looking for one link that's broken or missing. And links break for boring human reasons. Banks fail and get absorbed by other banks. People die and nobody moves the deed. A clerk mistypes a middle initial. A deed gets signed at a kitchen table and dropped in a drawer instead of recorded. A city records a lien for a fence you never knew was a violation. Now here's what makes this brutal. You find out last. The title search doesn't get ordered until you're already under contract. So a problem that has been sitting in your chain for 20 years lands on you with a buyer, a lender, and a closing date already stacked on top of it. And everyone in the room looks at you like you did something wrong. You didn't. And I'll tell you right now, most of these take far less time to fix than you're about to be told. One more thing before the list. If you inherited the house, if you're going through a divorce, if you own it with siblings, you are the most likely person to hit one of these. Not because you were careless, because your chain has more links in it. Let's go through all 5. Number 1, an old mortgage that was paid off but was never released. You paid that loan off in 2009. The bank never recorded the satisfaction. So on paper, it's still a lien on your house. This one is everywhere in South Florida because so many of the lenders from that era no longer exist. They failed, or they got swallowed by a bigger bank. Here's what most people don't know. Florida law gives that lender 60 days from your full payoff to send you the recorded satisfaction. If they blow it, you send a written demand. They get 30 more days. And after that, they owe you $500, plus your actual damages, plus your court costs and attorney's fees. So how do you fix it? Your title company traces who owns that loan now and gets the satisfaction recorded, usually free. Usually 2 to 6 weeks. Worst case, a quiet title action. Number 2, your name is wrong on the deed, a misspelling, a missing middle initial, a maiden name on one document and a married name on the next, Bob on one deed and Robert on the other, a dropped junior. Or the legal description is wrong. Somebody typed the wrong lot or block number. People panic at this one. Don't. For a name issue, a name affidavit signed at closing usually handles it entirely. For a legal description typo, Florida has a specific curative procedure. You record a scrivener's affidavit, and the deed then reads as if the error was never there. There are conditions on it, so your title attorney has to confirm it applies. Cost? A couple $100. Time? Days. This is the cheapest problem on the list. Number 3, a deceased owner is still on the deed. Mom died, dad died, a spouse died, and title was never moved. You cannot sell what you don't own on paper. This is the one that stops the most sales in my market. And here's the part that changes everything for people. They hear the word probate, and they picture a year and $10,000. Florida has a shortcut called summary administration. You qualify if the estate subject to administration is $75,000 or less, and homestead property does not count toward that number. Or, and this is the one nobody knows, if the person has been deceased for more than 2 years, regardless of the size of the estate, because after 2 years, creditor claims are barred, no personal representative, no inventory, no creditor period, typically 4 to 8 weeks. So if your mother passed in 2021 and the house is still in her name, you are probably not looking at full formal probate. Number 4, a deed that was never recorded or wasn't signed correctly. Grandma gave me the house, and the deed is in a drawer. An unrecorded deed is dangerous in Florida. A later recorded interest can beat it, including a creditor of the person who gave it to you. And here's the technical one that catches families. A deed conveying Florida real property still requires two subscribing witnesses, plus a notary. The law changed in 2020 to drop the two-witness rule for leases. It did not change for deeds. So a deed signed at a kitchen table, with the notary as the only witness, is defective. If the person who gave it to you is alive and willing, re-sign it correctly and record it. About $200. If that person has passed away, this becomes a probate or quiet title problem, and it gets expensive. So the lesson is simple. Record a deed the week it's signed. Number 5, liens you don't know you have. Code enforcement lines. Municipal utility balances, open permits, association assessments, contractor liens, judgments, tax liens. Most people have never seen their own title. But here's the fact I most want you to walk away with. A recorded civil judgment does not attach to Florida homestead property. That's Article 10, Section 4 of the Florida Constitution. It will show up on your title search. It will scare you. And against a qualified homestead, it is constitutionally unenforceable. The exceptions are property taxes, the mortgage itself, and labor performed on the property. To find all of this, you order a municipal lien search, about $150 to $250, and code liens are frequently negotiable. Cities routinely reduce accrued fines once the violation is cured. Now let me put dollars on a real-shaped example. These are illustrative numbers. Not one specific family, 3 siblings. Mom passed in 2021. A Broward house, worth about $400,000. The title search finds 3 things. Mom is still on the deed. A 2004 mortgage was never satisfied. And there's a code lien from an unpermitted shed, $18,400. So here's the repair bill. Summary administration. She's been gone over 2 years, about $2,800. The satisfaction. The servicer produced it in 3 weeks. Free. The code lien. Negotiated down to $4,200. Total, about $7,000. Total time, about 10 weeks. Now the cost of doing nothing. That house carries at roughly $1,150 a month in taxes, insurance, and upkeep. And the code lien keeps accruing $7,000 and 10 weeks to unlock $400,000. That is almost always the right trade. And if you can't carry it for 10 weeks, a cash buyer can take it subject to the problem and clear it themselves. That's less money in your pocket. That's the trade. I'll always tell you that straight. Send me your address. I'll pull your title chain and your municipal lien search and tell you which of these 5 you actually have. That's free, and I'm not going to chase you. HomeRescueTeam.net or call 305-699-9763. If this made the phone call less scary, subscribe. I put these out twice a week for Florida families.